Let's go ahead and begin. Good afternoon. Today is September 5th, 2024. It is approximately 1 p.m. This is the matter of the application Z0172-24, an application for a conditional use permit by Trilogy Med Waste West. My name is Carl Cox. I'm a private attorney appointed by Clackamas County as Land Use Hearings Officer with authority to conduct this hearing and make a determination in this matter. I will state several important things for the record. First, I have not received any ex parte contact in this matter, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I received and downloaded and reviewed the county's staff report and related exhibits, including application and related things submitted by the applicant. And I was able to also review some additional exhibits that were provided late. I will state for the record that I've considered issues of bias and conflict of interest, and have determined that I do not have any bias or conflict of interest in this matter. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. The county is making a record of this hearing. That record is available through the county, and prior to the end or close of the record, I will make a statement giving participants an opportunity to request that the record stay open. At this time, I'm asking that the county provide an explanation concerning participation in this hearing via the Zoom platform.
Thank you. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, the county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their microphones muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. For attendees on PC and an iPad, you have a raise hand button on the Zoom bar, either at the top or bottom of your screen, depending on your device. When the moderator switches you over to provide your testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who's speaking. Staff will call upon you when it is time for you to provide your testimony. Be sure to provide your name and mailing address when you begin. Once you've provided your testimony, your microphone will be muted and your screen will be returned to normal. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you may email your written testimony to myself at mlord@clackamas.us or mail it to Clackamas County's Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, 97045. My contact email address is also available on the webpage where you found the link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's decision. If you do not wish to testify, but would like to receive a copy of the decision, you must provide your email or standard mailing address to myself at mlord@clackamas.us or by entering it into the Zoom chat function during the hearing.
Thank you. The order of proceedings will be that I'll ask the county to begin by presenting the county's staff report, and I see that Ms. Lord has created a PowerPoint presentation to share. Also, will that PowerPoint presentation be submitted as an exhibit?
Yes, it will.
Okay. Please begin. Oh,
Great.
followed by an opportunity by the applicant and then the general public. Go ahead. I'm sorry.
Thank you. So my name is Melissa Lord. I'm speaking on behalf of the Planning and Zoning Division today as it relates to land use application file Z0172-24, which is a conditional use permit. The subject property is located off of Highway 212 in the Clackamas area. The property is zoned light industrial and surrounded by properties also zoned in similar light industrial zoning designations. The applicant proposes to operate a biomedical waste transfer station or facility in a portion of an existing building on the site. The transfer station will operate exclusively within the building, not exterior or not outside to the building, and there's no new construction being proposed or new site work being proposed with this land use application. At this time, we've not received any comments from anyone in the public, and the initial recommendation from staff was a denial, as detailed in my staff report. I will cover those details somewhat during my presentation as well, but the staff report is entered into the record as exhibit number 1 for a full analysis that we did in order to come to this conclusion or this recommendation of denial. There were only 2 main components or 2 main review criteria that we found weren't being met by the applicant. So I will touch on those near the end of my presentation, but a large majority of the relevant review criteria were being met. And so I also want to touch on those very briefly as well. Recycling centers and transfer stations are listed as a conditional use in the zoning code, which is why we're reviewing this as a type 3 conditional use land use application. Some of the review criteria pertaining to conditional use permits include first, an evaluation of the characteristics of this property and why this particular property is suitable for the proposed use. In this case, the location of the subject property is suitable as it's located on a designated truck freight route. Highway 212 as well as Southeast 135th Avenue are designated in the comprehensive plan as truck freight routes. Not only is this a requirement from our zoning code section 819, but it also adds to the fact that this particular site and its location is suitable for the intended use. The existing improvements on site also lend itself to making this a suitable site for the proposed use. Vehicle maneuvering areas, existing parking areas, and the building itself, the tenant space for this warehouse industrial building, make this the suitable site for the proposed use. Next, we needed to evaluate whether the proposed use was going to significantly alter the character of the area in a way that might impair or preclude the use of surrounding properties. Like I mentioned just briefly earlier, the surrounding area is largely industrial, certainly zoned industrial and in industrial uses predominantly. So this would be compatible with the existing uses in the surrounding area. As I've gleaned from the application itself, there doesn't appear to be any noise, light, glare, or odor that would come from the operation of this transfer facility. because they are operating exclusively indoors to this site. And so in the context of evaluating whether these types of features might substantially limit a surrounding property from utilizing their property, we found that the proposed use wouldn't. And so therefore, we did find compliance with this particular criteria as well. When we look at things like water, sanitary sewer, and surface water management, all of these particular subsections of our code we found to be compliant with the proposal. We received signed preliminary statements of feasibility from each one of the providers, the water provider, sewer, and surface water management authority, confirming that as proposed, yes, they have adequate facilities to support the proposed use. Section 1007 of our zoning code looks at roads and connectivity. The site is already developed, and as are the roads and the sidewalks and infrastructure surrounding this property as well. The site was originally developed as a result of an approved land use application, a design review application in 1996. And so it was developed shortly after. And as I mentioned, it is on a designated truck freight route. The applicant doesn't propose to have any new access points onto Highway 212 or the surrounding roads. So everything that is existing is what they're intending on using here. So we didn't have to evaluate adequate access because it's already there. Frontage improvements were exacted previously due to that 1996 land use application. So there's no need, we found no need to exact any more improvements as they're already existing. When we look at parking, there is adequate parking available. The site, as I mentioned, was already developed with a land use application, and it was developed specifically to support industrial types of uses, so warehousing, storage, and things of that nature. So the parking associated with this development has already been designed as a direct result of the expectation that the building would be used for types of uses like this. Section 819 of our zoning code has very specific standards that relate to waste transfer stations. And so this is where I found that there were two particular zoning criteria that I didn't find were being met, or at least that the applicant hadn't demonstrated enough evidence to meet these two particular standards. The first being air quality. The zoning code says that the discharge of contaminants created by the facility shall not exceed the Oregon DEQ's air quality standards. We did send out notice to DEQ, and in an email correspondence did hear from them just yesterday related to air quality standards.
I saw that.
Okay, good. Yeah, they did provide us two sections of the OARs that have applicable air quality standards. And in the submitted application materials the applicant submitted, I didn't see any direct reference to these OARs, at least substantiating how they may comply or how they believe they could comply with these OAR standards for air quality. It is the applicant's burden of proof to demonstrate that they've complied with all relevant review criteria, and that would include this particular section of 819, which is why the recommendation on my staff report was a denial just due to a lack of evidence supporting this particular criteria. I will note that in that email exchange, the DEQ representative had mentioned that they won't be signing off on any permits until a land use compatibility statement, or a LUX, was submitted by the applicant to DEQ. There is a question of whether or not planning may or may not be able to sign off as on that LUX. It just depends on the form itself. Some agencies have a box where planning can tick that says they've applied, the applicant's applied for the necessary permits and hasn't received a final decision. However, some of these forms just have a yes, you've received your permits, or no, you haven't. So depending on that specific Lux form, we may or may not be able to sign it at this point. But regardless, I think whether DEQ is reviewing an application for their own standards currently is not necessarily relevant to the applicant providing necessary evidence in their land use application that would support whether or not they can meet, or at least seem to meet, the air quality standards for the DEQ. So
Is there a proposed condition of approval related to meeting this?
Yeah, so I think I would recommend maybe two options, either leaving the record open so the applicant could provide additional evidence, at least having them demonstrate how they believe they could meet these OAR standards. Alternatively, conditioning the application on complying with the DEQ regulations just as a blanket statement. I did provide, or at least I intended to provide, a recommended condition of approval that relates to that in the staff report, and I can just verify that really quick.
I noted that the email submitted by DEQ said they don't enforce this.
That's right. They did provide an email saying they don't enforce the noise regulations from DEQ.
Or the air quality either.
Okay. And I think enforcement might be a separate piece. They would then compliance, perhaps.
Oh, that's true. The
Yeah.
regulation still exists.
And I did recommend, if you choose to approve the application, condition of approval for B, which would be the applicant shall comply with DEQ standards for air quality and obtain necessary permits. Just in case.
Go ahead.
Okay. A good segue into this would be talking about noise standards. So similarly, I think the applicant provided in their application materials certainly some references to the relevant noise standards from the OAR. In an email correspondence 2 days ago from the DEQ that started, they provided additional ORS standards that are applicable. So in my staff report, I did review the OAR references submitted by the applicant, and I think they identified some of the exempt noise standards, but perhaps not all of them, based on my review of these OARs that apply. Again, I think we could, in my opinion, we could go either way of just having a recommended condition of approval that says they ought to comply with the DEQ standards and get any necessary permits from DEQ. Alternatively, just leaving the record open to provide additional clarification or evidence in this land use application from the applicant to demonstrate further how they intend on meeting all of the relevant OAR and ORS standards that pertain to noise being emitted from this particular use. To your point, the DEQ sent a document that it describes how they don't actually enforce any of their standards, and that's the county's job, but nonetheless, they still have standards that will have to be met, it sounds like.
And if you receive a complaint, then that is your standard, and you need to know in advance what the requirement is for them to comply. I understand.
That's right. Yeah. And I think to that end, it's, at least I think it's important to at least have some level of confidence when looking at the land use side of things that we'd be setting the applicants up for a successful application in a sense. So not conditioning a land use application on something that maybe they can't obtain, and so I think, at least with what was supplied in the land use application related to noise, it seems like the applicant's going to be able to meet the noise standards from DEQ, of course, subject to any permitting necessary by DEQ. There's just a bigger question mark from lack of information related to the air quality related to this application, in my opinion. So again, I think my recommendation would be to either leave the record open and gain a little bit more information or evidence related to both of those standards and how specifically the applicant thinks that they may or may not comply with the OAR and ORS regulations surrounding noise and air quality standards, or alternatively just condition the application to comply with those DEQ noise and air quality standards, as well as other recommended conditions that I've presented, because it really was just those two specific issues that I found with the application. Otherwise, I think the applicant provided a very comprehensive application that definitely complies with all other relevant review criteria. So with that, that concludes my presentation. And if you've got questions, I hopefully have some answers.
Thanks. And you were terrific and patient about answering my questions as I interrupted your presentation.
Of course.
I'd like to provide the applicant an opportunity to submit information, testimony, evidence that the applicant wants me to consider in making a decision.
Yes, sir. So in regard to the noise levels, the rules in the ODEC kind of give different levels of noise levels.
You're cutting in and out a little bit. Can you move to your mic a little closer, please?
Is that a little better?
Well, go on.
Okay, I can change the mic if we need to. In ODEC, it does have different rules on the levels of noise. However, I made reference to the vehicle movement and vehicle noises because that would be the only noises created outside of the warehouse itself, because all activities are occurring in the warehouse. So it wouldn't be much more than ambient noise levels once you pass, a couple feet from the door. So if the doors are closed, and they'd be pretty much muted from the inside. It's not a very noisy operation to begin with, and then being enclosed, it virtually goes back to the ambient noise levels.
And inside the facility as well?
Inside the facility, there will be a slight increase of probably 10 to 15 decibels above ambient, just for different movement, such as like a forklift or a tipper being moved or a tub washer going through. You'll hear the cycling. So it does raise it 10, 15. I can't remember what the rating is, decibels. But we've done studies at our other facilities, internal audits ourselves, and I've done rated hour readings that were very, very low in the 50, 55 area. But they did spike into into the 80s, low 80s at certain areas. Like if an air compressor turned on, that condition noise does kick it up. But the weighted hour rating is right around 50, 55 or 54.
Okay.
So this is why there and because there's no permit to apply for, that was probably my confusion. Since it's not enforced by ODEC, then a permit is not required, and that's why I kind of didn't really submit much more than that information about the trucks outside.
Do you have additional information to submit supporting your statements?
I mean, it is in
the application.
Yes, right. In the newest emails saying that it's the way they don't enforce the noise or issue permits for noise. That is in the latest emails. Yes, sir.
Okay.
Is there anything else that would be needed beyond that?
I would consider any kind of evidence that in support of your study concerning the noise levels not exceeding ambient noise levels, or your reference of how you measured the internal noise.
Okay.
If you wanted to submit that, I'm not requiring it.
Okay.
Okay.
Yes, sir. Go ahead. Sorry.
Did you have additional information you wanted me to consider?
Beyond what's in the regulations, and there's no permit required, and we're looking at. I mean, I'm not sure we would be able to go out and test the noise levels, but since we're not operating at all, inside the warehouse, it's hard. It's a false reading. I mean, it is ambient inside the warehouse because there's no activities. So it's kind of hard to prove that negative. Um, and that's where my kind of my not frustration but anxiety came from, was where, how do I prove that with nothing there, how do we prove that it will not? And then the only thing I can think of is doing a um, a test at another facility, but I didn't think that was, I didn't know how relevant that was because of a permit not required.
Okay. Did you have more information that you wanted me to consider? It looks like those are the two primary issues, noise and air quality.
Yes, sir. And then on the air side, there was, as part of these email exchanges, I did submit, when I talked to ODEC, I finally got a hold of someone. I'll be honest, it was a little difficult communicating back and forth. But they're very responsive once you get a hold of them. But so basically what ODEC told me, it's in the email as well, but basically it said that you need to submit an application for them to determine if you need a permit. So it's kind of like a general questionnaire, uh, uh, determining what permit you may or may not need. So, and if no permit is needed, then it's more of an information that they keep their records of. So we do have intentions of putting a boiler in at some point, and that would be the only piece besides
I didn't catch that. Intentions of putting up a what?
a boiler.
A boiler.
Yes, sir.
Oh, okay.
For the recycling process, the MERC process, of the treatment of the biomedical waste.
Right.
Besides the boiler, they would also, the only other item, as I went through the different pieces that we may have in there, for the kind of the transfer station application, or to increase our we can treat the waste instead of sending it to the incinerator in uh, Marion County. So I'm not sure if you're aware of, they've had some changes there, making our life a little difficult. So, and this is kind of why we want to kind of step up our game a little bit, our processing to include a boiler. But that would be the only piece besides possibly putting a generator that is not for emergency use. So if it's for emergency use only, they would just like to be notified that it's there. So I did submit an application on a boiler that would be equivalent, such in our other facilities, and that's what I did submit to ODEC, and their response back was basically they won't actually review the application until a Lux is completed, and then that's what we're hoping to do here. I just want to be open and honest. We're very transparent. We'll do whatever is necessary to do it correctly. Our intentions are always the legal, moral, and safe. Those are our intentions. So,
I have a couple questions for you.
yes,
Hang on. Just a minute. Trilogy. Okay, I received also late September 4th, so yesterday,
yes,
from Eric Bertram, Water Environment Services. Did you have an opportunity to see this as well?
I,
It is comments, and it also is a reference to particularly like discharge regulations. It cites the authority that it operates under, industrial wastewater discharge permit requirements. It reads to me like proposed conditions of approval for in the event that you are doing any industrial wastewater discharge. Did you have an opportunity to see that? It did
I,
come
I,
in.
yes, sir. I did look at it. I mean, this is my top priority because it does take a amount of time. So I want to make sure we don't miss any deadlines and opportunities to progress our application. Basically, what happened not what happened. What occurred was during part of the application process for the conditional use, I submitted a sample of wastewater discharge at another treatment facility that we have that would be somewhat, it would be a kind of equivalent. So, and they had a chance to review, and there was nothing that they noted that would be requiring a permit for discharge. However, if something does change, they want to make sure that I'm aware that we have to apply for a discharge permit if we meet conditions of another level. So,
Okay,
and as we grow, I mean, we should have conditions where we cannot do X, Y, Z next step until these other items are met. Right now, we're at the baseline, and then we want to grow to a higher level and keep extending our operations.
all right. So you don't dispute that you have to meet these requirements?
Correct. Do not.
So, but at the current time, your proposal, while you may, as I understand what you're saying, the facility may engage in activity which triggers these requirements in the future, but you don't intend to start that way.
Correct.
And if you do, then you'll need to engage in some alteration to the facility because as I read it, let's see, uh, shall maintain at the industrial user's expense a sampling manhole, that's something new, materials and fittings, suitable monitoring access for inspecting, sampling, and investigating discharge. All of that looks like something you'd have to build out, correct?
If when we get to that point, yes, sir.
Okay, okay. So I just wanted to make sure that there were no surprises here. Did you
No,
have
no.
the opportunity to read Ms. Lord's proposed conditions of approval as well?
I did, and I do appreciate all of her time. She's been very patient with me, so I would like to say thank you to Miss Lord. But yeah, I did have a chance to read over them, and really the focus was on the noise and air issues or concerns, and I would definitely propose as well that we would get a conditional. If it's conditional upon meeting criteria. So as we move forward, even from the day when we have new criteria, we'd have to do another modification. So
So conditional on meeting current as updated kind of thing. Okay.
yes, yes.
Wow. Is there something else that you want me to consider here? Or
Uh,
sure you make sure you discuss it. This is our time.
no, that is it. And hopefully I've answered any lingering questions about the application so we can make this complete and sign off with conditions.
And before I close, is there any member of the general public who is present here? Okay, so I just want to make sure that I provide that same opportunity. So no, and did you have input from one of your associates that you wanted to call upon?
Um, Unless they raise their hand, then we're in different states, so there's no way to really tell what they're thinking at the moment. We have discussed this, so we are all on the same page. We are very open in our operations, and I'm on the compliance side, so my main focus, I really drill that in. Jeff Norton, just so you know, is the district manager. Jesse is the local facilities manager. He covers multiple facilities, but this will be a new facility for him. And then Rob is the HR chief of HR, chief HR officer. Yeah,
I'm just the head of HR. You don't have to worry about the title. I guess I would like to raise something, and maybe Jeff can build off of this. But right now, just for some additional context, we gather waste from a lot of your providers in the local area. We have to take it all the way to Tacoma, and we'll save or reduce emissions in your state by not having to drive it back and forth. Once we can do more in the Clackamas facility. So it's maybe that's more important to the DEQ, but it will reduce, transportation that is currently required because of, without the permit, we have to do everything up in Tacoma. We can gather things. So we'd love the ability to serve your customer base better. And we need the permit. We need, obviously, go through the right steps to get the permit to do that. So, we're trying to be a good business for your medical providers, your dentists, everybody that produces medical waste. We're trying to help make that more efficient for the local team. So Jeff, I don't know if you want to.
Well, I'll also just say that we have been working with DEQ and Metro very closely. So we have had a lot of pre-meetings already with them as far as on the solid waste side. So there's a lot of help that they've also given us just on the waste side. They see a need for what we're doing because currently in the state, Chad mentioned it a little bit, but Covanta in Marion County, the waste to energy incinerator is the only approved transfer station and processing for Oregon in the whole state. And we were told a couple months ago that it's probably shutting down. I actually have a call next week at the end of the year that it's going to shut down. We currently take most of our waste up to Tacoma, but it still comes back there. So we're going all the way up to Tacoma to transfer it and then send it back there. And so there's, I would say the DEQ and Metro have been really helpful. And a lot of it really relies on this land use that we're doing right now. So anyways, just thought I'd put that in.
Thank you for that.
And one last thing, Jeff, you may be able to help me with this one, but we are approved by Clackamas County on the solid waste side as the hauler. Is that correct? If you can explain that.
That's correct. As far as the franchise authority, we are the official subcontractor for all of the haulers in Clackamas County for the medical waste. So we're picking everything up in Clackamas County currently, as well as a lot in Multnomah, but in Washington County as well. We do everything in Washington County as well. So we're the approved subcontractor. So we do work closely with the county on that side with Rick and his team.
Thank you. Does the county have something further for me to consider, or anything that the county wants me to add here?
I don't. Thank you.
All right. Thank you. So for the record, I'm going to state, does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? And if not, does the applicant wish to waive the period for final written argument? So what is discussing is this is going to be the close of the hearing. The record will close at 4 p.m. today if I don't receive a request from someone to keep the record open for a longer period. So if you want to submit something more for me to consider, some evidence, a written support, any kind of document, you need to make a request for me to keep the record open so that I'll get it and can consider it. And if not, I'll close the record at 4 p.m. And you can either way keep have a last word in this. If you just want to submit a written statement reiterating the evidence that you've already said or stated, and just make sure that I didn't miss anything, you can do that as well. So any requests to keep the record open?
I do not have one. I believe we've supplied everything verbally, and I appreciate the time.
Sure. Thank you, sir. Does the applicant wish to waive the period for final written argument?
Yes.
Okay. Then the record will close at 4 p.m. today. I did note that Ms. Lord is going to submit her PowerPoint presentation as an exhibit by 4 p.m. today. And I did receive the exhibits that we discussed today, including through that, I think it was exhibit 10. So there are 10, and so your PowerPoint will be exhibit 11, I believe.
That's correct.
Okay.
Yeah.
All right. With that, I'll close the hearing. I will take all of this under consideration. I have a little bit of extra work to do here. There's some open issues that I'll have to resolve, and I will do my best. I should have it within 2 weeks.
Okay, oh, perfect. That's my only question.
I anticipated it. I have been asked before.
Yeah, I believe you have. I've asked it many times before. So, yeah, we are 32, 33 facilities across the country. We pride ourselves on our compliance and safety and our operations. So, hopefully we can add this to our infrastructure. And I do appreciate everyone's time today.
I appreciate it. Thank you. It was nice to meet you all.
Thank you.
Thank you.